Activities have no detailed limitation or boundaries and may take time too. I am alive to the fact that the investigations cannot take forever to conclude. That fact notwithstanding, I am greatly disturbed by the fact that the respondent, applicant here with IRA, proceeded to rely on a lapsed order that had no basis in law. I share the concerns shared by counsel to the interested party that this was and is a gross violation of the interested party's rights. The respondent applicant was granted a period of 14 days with an option to extend these orders on the 23rd of December 2019, pursuant to an inter-party hearing date. For whatever reason, the applicant or respondent did not seek any such orders to be extended as was contemplated. Certainly, the period for investigation must not be an indefinite period, and should the same be subject to an extension. That extension should be authorized by the court. Curiously, I did not read or hear anywhere in the submissions of the counsel for ARA an explanation regarding why the respondent did not honor the hearing date for the 23rd of December to seek an extension of the orders if it was necessary. The order for 11th of December 2019 had automatically lapsed by the 24th of December, and as such, the applicant ARA had no legal basis to rely on the said order, as they did not seek further orders from the court, nor seek to have their aforesaid funds preservation reinstated or extended. Section 121 of the Criminal Procedure Code indicates further detention of seized items is to be done with the direction of the court. Section 121, subsection 3 further directs that, quote, if no appeal is made or if no person is committed for trial, the court shall direct the thing to be restored to the person from whom it was taken unless the court sees it fit or is authorized or required by law to dispose it, otherwise, end of quote. The applicant's case is that the continued freezing of the subject bank account is against the law. The above provision emphasizes the earlier fact that once anything is seized, there must be a return date to court for the thing to be seized or to be dealt with in accordance with the law. For the purpose of the purpose of this requirement is to inform the court of the outcome of the search and inspection and to get direction on whether or not to seize the subject matter or the seized subject matter will be maintained. There was a failure on this part. The return date of 23rd of December, but the return date was the 23rd of September 2019 was not honored by the ARA, neither did they approach the court to extend the same orders, yet they continued to rely on the same lapse orders. This was in bad faith on the part of the applicant hearing. More concerning is that the applicant, through the investigator, does not propose a specified period of time within which they will be able to complete the investigation, even after they had more than 14 days after the orders expired. Notably, some of the frozen accounts do not even belong to the interested party himself, but to people thought to be associated with him. Any continued freezing of the said accounts will, in my opinion, highly be prejudicial to the interested parties and the other account holders said to be associated with the interested party, yet not disclosed to the court. It therefore follows that the application by the interested party is allowed, and the respondents here are directed to unfreeze their respective accounts, and the application by the applicant, the initial application by the applicant, that is the asset recovery agency, is hereby disallowed.
Frozen accounts of His Excellency the Governor of Nairobi County, Mike Sonko, moving should be forthwith unfrozen. There was no evidence that was established by the ARA for the freezing of those accounts. And the court also held that when they were given the order ex parte, at that first instance, the life of the order was 14 days. And they were told to come back to court on the 23rd of December 2019 after you have served all the banks and informed the governor that you have frozen his accounts. They didn't do this. They didn't even go back to court. After they obtained this order, they sat on the order and they went on a mining spree to mine data to find out if there was any incriminating evidence, and they found nothing. They did not find a cent to have moved from the county government coffers into his accounts. All of those accounts, including mortgage accounts. So the court has said, for what reason then can you continue freezing these accounts? The law permits you to freeze an account if you find there are proceeds of crime or there is money laundering involved. But there was no evidence there were proceeds of crime or money laundering in these accounts. Consequently, it stands to truth in the fact that they should be unfrozen. And then also the court observed, once the ARA obtained these ex parte orders for 14 days, having a lifespan of 14 days, they did not go back to extend these orders. Rather, as early as this year, way after the time had expired, the ARA goes to the banks and says that we have a court order that we obtained on the 11th of December, and we want to use this order to freeze these accounts. The court has said that was an illegal order, and that was an intrusion into the privacy of His Excellency the Governor. And therefore, it is a warning to those who want to flout the law and at the same time represent to the public that there is a crime that has been committed. We should stop this legal gangster regime. Kupiga ngeta watu kwa kutumia sheria jinsi mnafanya. Tafadhalini tuache hayo. Manake tuna sheria na utaratibu wa sheria lazima tuufuate. Mahakama imeamua lazima tufuate huo utaratibu. Na ARA hawakuwa na utaratibu wa sheria ambao waliofuata. Manake walipewa ile order mhula wa kwanza tarehe 11 mwezi wa 12 mwaka uliopita. Lakini kisha baadaye hawakurejea mahakamani, manake ile order ilikuwa na uhai wa siku 14. Kisha baadaye hawakurejea mahakamani tarehe 23 mwezi wa 12 mwaka uliopita. Sasa mahakama ingesema, je, wakati huu ulipata hii order, wewe mwenyewe weka mezani ushahidi ambao unathibitisha kwamba kuna pesa za ukatili au kuna pesa za ufisadi ambazo zimeng'olewa kule county government na zimeingia kwa account za governor. Hamna hata hela moja. Kwa hivyo jinsi gani tuendelee kufreeze hizo accounts?
And the genesis of the instant application before this court is the order issued on the 11th of December 2019 by my sister, Honorable Milimani. The asset recovery being the applicant ex parte at the time, approached the court seeking orders to have several bank accounts held by associated with the interested party to be frozen by the respective banks who are the respondents, pending investigations of the said accounts on suspicion of money laundering activities. My sister allowed the application by the applicant ex parte and issued an order for restriction of the bank accounts for 14 days only and set into party hearing dates for the 23rd of December 2019. The hearing did not take off on the stated date, and the interested party approached the court by way of notice of motion supported by an affidavit dated the 31st of December 2019, seeking, among other orders, that an order do forthwith issue to review, vary, vacate, set aside, and discharge the order herein made on the 11th of December 2019. The interested party through its counsel submitted that the asset recovery legacy was flashing to the applicant's or interested party's bank accounts a non-existent lapsed order issued ex parte by Honorable Riani on the 11th of December 2019 and which consequently lapsed on the 27th of December 2019, having never been extended after the initial 14 days granted lapsed. On the 24th of December 2019, the applicant was informed by his bankers that his accounts with the first, second, fifth, and seventh respondents were still frozen as a result of the order of 11th of December 2019. Council submitted that the Asset Recovery Agency ignored the directions of the court to attend hearing on the 23rd of December 2019 for the inter-parties hearing, and that no service of the proceedings was effected. Council contended that the interim orders issued on the 11th of December 2019 were not therefore extended on the 23rd of December 2019, as the record is attested, yet the Asset Recovery Agency continued to represent to the applicant's bankers that the said orders of 11th December were still valid when, in the actual fact, they had since lapsed. Council submitted thus that this court intervenes to stop injustice being occasioned to the applicant's interested party, since the order of the 11th of December 2019, having not been extended, the said order is in nullity terms. Council contended that the said order is ineffectual, cannot be legally enforceable, having lapsed, and ought to be formally vacated forthwith. Council further submitted that notwithstanding the foregoing, did not name a single bank account or transaction belonging to the applicant, such as ex parte oppressive orders, such as would meet the statutory threshold to grant such revenue. It further submitted that it was an extremely dangerous precedent that the whole constitutional rule to freeze the applicant's specific bank accounts based on unspecified and nebulous statement of blank accounts treated by the Asset Recovery Agency in the manner as has been described in this instance. This is unjust and fishing expedition that violates Article 50, Sub-Article 4 of the Constitution. Further, Council contended that Section 121(1) of the CPC merely permits the court to order a seizure of a specific object or item, and that it ought to be brought before court and not to freeze an account in situ indefinitely. Since the warrants to Corporal Isaac Nakatari were sought and granted ex parte, both sections 118 and 121 of the CPC impose a statutory condition of a return date, which was breached by non-service, and hence the orders were out of section 121 of the CPC. If I submitted that section 121 of the CPC stipulates by implication that any further restriction of the funds subject of the orders granted exclusively under the direction of the court and not that of the investigating officer. Such an opportunity by way of return date was deliberately denied and deprived to the applicant to challenge the unlawful freezing of his account, of his bank accounts, which is why he seeks a joinder forthwith to this proceedings. Council further went on to state that at any rate, no proceedings known to or against the applicant may have been procured or by Asset Recovery Agency against him or pursuant to the proceeds of crime and anti-money laundering acts. And such proceedings being subsisting in relation to the subject matter herein, Section 89 of the Proceeds of Crime and Anti-Money Laundering Act confers upon the High Court of power, on evidence by the applicant, to vacate, discharge, or vary such draconian, unlawful, and constitutional ex parte orders as now secured by the Asset Recovery Agency. Council further submitted that Sections 82(1) and 2 of the Proceeds of Crime and Anti-Money Laundering Act, which provide the guiding principles for the court to make any preservation orders, were never invoked by ARA in its stated motion in these proceedings, such being the statutory basis granting statutory jurisdiction for the issuance and validity of such order, no reason subsists or was provided for their non-invocation. On the issue of breach of fair trial rights under Articles 25C of the Constitution, Council submitted that Section 102(2) of the CPC is contemplated to apply in any application made under Section 118 of the Criminal Procedure Code, with provision envisages a return date to court wherein a respondent, such as the applicant or interested party herein, is accorded a platform to challenge the ex parte order. This provision was fatally breached by the ARA in not serving on the application, on serving its application on the interested party, or even returning to court on the 23rd of December's audit. Council further submitted that the interested party was never summoned nor served with the application by ARA relating to the alleged transactions on the 5th of October 2019 mentioned in paragraph 5 of affidavit of Corporal Isaac Nakitare, sworn on the 10th of December 2019 in support of a motion, thus depriving the applicant the basic rule of fair trial and non-derogable under Article 55C of the Constitution that no man should be condemned and hurt. Further, it was submitted that the court ought not to have frozen the applicant's accounts covering the nebulous period of January 2017 to date. There was no single development by Corporal Isaac Nakitare demonstrating even a prima facie basis the nexus or at a minimum superficial basis for such a wide span of bank transactions in the specified accounts of the applicant, which constitutes a facial exhibition and altogether in express violation of Article 31 of the Constitution. It was the Council's contention that the stark failure by ARA to enjoin the applicant's interested party hearing to the proceedings and or to give a return to court upon service of the process on the applicant amounted to a violation of the applicant's right to a fair trial under Article 25C and Article 51 of the Constitution. It was further submitted that the process of the court was grossly abused by ARA in a manner calling for the vacating of the ex parte orders and that the freezing of the applicant's bank account in the manner complained of is manifestly unjust, oppressive, unreasonable, unconstitutional, and altogether without merit. On the issue of lack of evidence to support a prima facie case, Council submitted that there was no demonstration, or it was not demonstrated, established, or even hinted at any link between the monies in the applicant's frozen accounts and unspecified city county government alleged lost funds pleaded in paragraph 4 of supporting affidavit of Corporal Isaac Nakitare, dated or sworn on the 10th of December, and the court was therefore misrepresented too. On the issue of abuse of court process by ARA, Council submitted that ARA derives its statutory powers from the provisions of the Proceeds of Crime and Anti-Money Laundering Act number 9 of 2009, but in a naked abuse of its powers therein provided and unmitigated abuse of court process, it crassly abandoned the said statutory regime and conferred upon it by Parliament, and instead purported to invoke the provisions of the Law of General Application under the Evidence Act and Criminal Procedure Act to secure then impugned ex parte orders. We went on to further submit that it was not open to the ARA to abandon the primary procedure stipulated in the Proceeds of Crime and Anti-Money Laundering Act and adopt conflicted procedure in the C3C by operation of Section 131 of the Proceeds of Crime and Anti-Money Laundering Act, provisions of the CPC and the Evidence Act increasing the said bank accounts are subservient, secondary, and in no way could they be invoked to replace or supersede the said act. He cited Section 131 of the Act, which provides as follows, quote, where there is a conflict between the provisions of this Act and the provisions of any written law with regard to any matter, the provisions of this Act shall prevail. End of quote. Council therefore urged the court to vacate the orders issued and as were draconian and oppressive against the interested party. In submissions or rejoinder, the asset recovery and account application and reply filed submissions dated 14th of January 2020 later canvassed thoroughly before court and submitted that their application was instituted after they received information that the applicant interested party had received the interested party had received information on the 5th of October in respect of accounts held in various banks that the said accounts had received suspicious funds. which were suspected to be subject of money laundering and proceeds of crime. On the 11th of December 2019, the Asset Recovery Agency sought orders to restrict debits, investigate, inspect, obtain information in respect to the said parties' accounts among our suspect accounts. The Honorable Court, having been satisfied with the application, granted the said orders in accordance with the provisions of Sections 118 and 121(1) of the Criminal Procedure Code and Section 118 of the Evidence Act. ARA further submitted that investigations into criminal activities may take time and the depth of investigations might not be predicted by the investigator, hence the need for an extension of the court orders to allow the applicant to complete the investigations. Counsel for the array invited the court to see or to be guided by the findings in petition number 437 of 2015, that is left building and general engineering versus the AG. They further submitted that there are reasonable grounds to believe that the said accounts received funds which are believed to be proceeds of crime, hence the need for further investigation. In view of this, they urge the court to extend the orders obtained on the 11th of December to 2019 to enable them to conclude the investigations. It is worthy of note that no time was specified by the asset recovery agents regarding the period of time that investigations were bound to take or for how long they intended. And do find as follows: some facts pertinent to this case are not in dispute, and is as follows: that pursuant to miscellaneous applications predicated on confidential information received by ARA to the fact that there was a possibility that the interested party or applicant had received in his accounts funds suspected to be proceeds of crime and money laundering, the Asset Recovery Agency obtained orders on the 11th of December 2019 to freeze the interested parties' accounts held in various bank accounts. The said orders gave the Asset Recovery Agency powers to restrict debits, investigate, inspect, obtain information in respect to the interested parties' bank accounts among other suspects' accounts for a period of 14 days. Inter-party hearing was scheduled for the 23rd of December, later 27th of December, as per the record of proceedings that neither took off, leading to the application by the interested party hearing. Application was allowed, the application by the interested party was allowed partly on ground 1 and 2 in the notice of motion, in that it was certified urgent and the applicant enjoined in these proceedings. On the first issue on whether the police investigator or the corporate secretary has a right to investigate, counsel for the applicant argued that corporate secretary lacked jurisdiction to investigate his client as his police officer, not an officer of the ARA. Counsel for the ARA in reply submitted that Isaac Nakitari was a police officer seconded to the ARA and therefore possessing the authority to investigate. Section 37 of Okama authorizes the agency or authorized officers to act. Hence, police who have been mandated under Okama as authorized officers have acted accordingly. Similarly, Section 55 of the Act provides, quote, a person who or a body which has functioning as established or even hinted at to link between the monies in the applicant's frozen bank accounts and the unspecified Nairobi City Council government alleged lost funds pleaded in paragraph 4 of the supporting affidavit. The ARA in reply submitted that they had received information on the 5th of October 2019 in respect of the interested parties' accounts having different accounts to reasonably suspect that the said accounts had received suspicious funds which are suspected to be subject of money laundering. The law permits law enforcement to act upon receiving a complaint or upon reasonable suspicion. Rule J in Kagane versus the AG set the test for reasonable and probable cause, citing Hicks versus Faulkner.